Good morning, everyone. My name is Dane Paisano, and I'd like to welcome you to our Education Station webinar regarding the 2017 Employment Law Updates. Thanks for joining us. I'm very pleased to welcome back Cindy Henry as our guest speaker for today's webinar. Cindy is the president of Integrated Resource Network, which is a private human resource consulting firm. And Cindy has worked with varying industries consulting on HR policy, recruitment and retention, and regulatory compliance. Today she'll be highlighting what you need to be aware of regarding laws that will affect the workplace and how to stay compliant. Before we begin, please be aware that you can submit your questions on the right-hand side of the screen during the webinar, and Cindy will address them at the end of the presentation. Also, if the slides are difficult to see, the WebEx client allows you to maximize the window to fit your screen. And with that, Cindy, I'll pass the baton to you.
Thank you, Dane, and good morning, everybody. Thanks for joining us today to learn what's new in California this year. You see on the next slide that we have two main topics, and while the topics are about legal compliance, it's important to know that I'm not an employment attorney, and nor can this be considered legal advice. There's a lot that maybe some of you have been reading as laws were changed, new laws came about, but together we will navigate some of the key things and some of my conclusions based on what we see in 2017. There really are no major new laws, just a number of added requirements or changes that we will touch upon today in the time we have. Moving on. Many of you know that there's a new I-9 form. There's been a new form since November. And to be sure you have the right one, the expiration date up in the right corner is 8/31/19. Depending upon where you go and where you read, I've seen we had to use it as of January 21st. An attorney said January 22nd. Needless to say, by Monday of this week, you want to be using that new form and only that new form. Be sure you disregard the old one that expired in March of last year so you don't accidentally print a wrong form. And you would not complete this for current staff, but only for your new hires. It's important to take a moment, if you haven't already, to review the entire procedures, documentation requirements. They're a little bit different. And it's important to know that when you have a new hire, you just don't give them the form. You definitely give them the document that has the ABC columns on it showing the person, the types of identifications that are possible for he or she to present. But you're also to give them the instructions on how to complete the form. And they only they only complete Section 1. If you have an employee who goes on to, fill in the information in the employer's part with the number from Social Security or the driver's license, you really need to discard that page and bring a new page forward so that you, as the employer, can complete it. You probably know that it can be prepared online now, which is very nice, but it's important that you print it because you have to have real signatures, not online signatures. The other thing I would point out is that certainly in California, probably throughout the country, you cannot ask for any additional IDs. And you probably know from years past, the employer cannot tell the new hire which IDs to bring in. You simply provide the document that shows him all the possibilities, one ID from column A, or one from column B and column C. But just be sure that they're free to decide what IDs they bring in. Another form that is that I have been changing for my clients is the application for employment form. Over the years, we have had changes in California that have resulted in what you see on the slide of what you want to have in the section where you ask about convictions for criminal offense. The first one regards marijuana-related offenses more than 2 years old. They're not to list those. More recently, you don't want them to put anything that's been judicially dismissed, ordered sealed, or expunged. And the new one now in California is any convictions, adjudications, or other court actions by a juvenile court. So if you don't have all of those three items in that section of your application form, you want to be sure you do, because you're guiding the applicant as to what you don't want to know about, because you can't consider it as you consider their application for employment. If you're in the city of Los Angeles, there might be additional limitations. If you're in healthcare facilities, there are limited exemptions, and you would want to connect with me or your employment attorney to investigate those if that applies to you. Also, on the next slide, I want to point out something that I believe is important because of changes, additions to California's Fair Pay Act, which I'm going to talk about a little bit. We've got some serious important changes in the Fair Pay Act. And while it's not legally required, I am recommending to my clients that they delete any salary information on the application form. We oftentimes will say, what are your salary expectations, to get an idea if we're in sync on what our job is going to offer and what the applicant is expecting. And of course, in employment history, it's very common over the years that we've asked, what was your ending salary, maybe even starting salary, ending salary. And under the California Fair Pay Act, none of that information can be the sole reason for setting a new employee's salary, which causes pay disparity. And I've worked with many clients. It's been very common that we've looked at what someone's been making, and so we could maybe start them lower than we might start someone else who would cost more. So just consider that. It's a strong recommendation to my clients that we do that, and it also suggests that we need to be careful when we're interviewing on the phone or a face-to-face interview. We need to be careful about the subject of pay, which I can talk about more in a minute. Moving on to the Fair Pay Act, the last webinar in October, we talked about this a great deal because it was effective January of 2016. It was deemed throughout the country as the toughest in the nation. We've always had equal pay for equal work, but California said at that time equal pay between employees of different genders for substantially similar work. It's our job as the employer to prove that we did not discriminate between men and women, different genders, in setting our pay. The other thing that we learned in 2016 is be sure you don't have any policies that say employees can't talk about their pay. We've had that law in California before, but with the Fair Pay Act in 2016, they definitely can talk about their pay without any retaliation, and they may anonymously report to the state if they have concerns. Now, 2017 has brought an expansion of the Fair Pay Act, and it prohibits salary or wage from being the sole factor in justifying disparity in pay, paying a man more than a woman because the woman hadn't been making as much. You possibly thought you could hire her at a lesser salary. And remember, there cannot be pay disparity when two people are doing substantially similar work. The other thing in January, this month in 2017, the law expanded to include employees of different race and ethnicity. So this gives you a bit more work to do in your audits that I recommended last year. The way, remember, we must defend ourselves in how we set wages and salaries. And the only basis of pay disparity by the Fair Pay Act is maybe you have a seniority system, a merit system, a system that measures production or performance, and other bona fide factors like someone has more education, more experience, more training, more qualifications for the position than the other person. So we talked in October about completing an audit. I think that if you haven't done so already, that's still an important thing to do. But if you did the audit and made sure you did not have disparity between genders, Now you'll need to do the same process to ensure there's no disparity between race, based on race or ethnicity. Other suggestions I made in October were you need to participate fully with managers in determining starting pay, pay increases, and bonuses, because you'll have the greatest knowledge of the Fair Pay Act and what is required. Your position descriptions can play a very important part in an audit, in your defending how you've paid people. Remember, it's substantially similar work. So just because the job title is different or the job description is different, if the two jobs really are similar work, you need to be careful that you are not discriminating based on gender, race, or ethnicity, even though the jobs in your mind are different. And we need to be sure that only bona fide qualifications are in the requirements for positions. Moving on, I provided this last time, just the kinds of columns on an Excel spreadsheet, if you will, that I would use to study our pay practices and to make sure we do not have any exposure to a Fair Pay Act claim. Moving on, your next, the additional steps I mentioned last time, you might want to look at policies, performance review, pay increase methods, and record retention even is impacted by the Fair Pay Act. So lots to do because of changes, not only because of the change in 2017, but in 2016 when the Fair Pay Act was upon us. So in December, the Supreme Court in California, through a particular case, of course, said that we must have no control over how employees spend their break time, and they cannot remain on call and available immediately to you. Now, in my policies, when I prepare employee handbooks for clients, there was a bullet that said employees must remain on site during rest breaks because this is paid time. That now is coming out of all of my handbooks, and you should look at your policies, your employee handbook regarding rest breaks, and be sure you don't have similar directives, because that would not be consistent with what the expectations are now based on this case. The next item, you may still reschedule a rest break. You know, you need to be sure that the work is being completed, customers are being served, and so it is possible you might have to delay it or make the break a little earlier than anticipated. But this case said that rescheduling should be the exception, not the rule, not unduly affect the employee welfare, and if you do so, reschedule the break, it's to alleviate a material burden to the employer. So we can all think about how we would maybe define differently employee welfare, unduly affect their welfare, material burden. So this is just to make you aware that as often as possible, keep your rest breaks moving along as employees expect and as you have generally practiced. Certainly, if a rest period is interrupted, or you can provide a different rest break during that first 4 hours of the day of the shift, or if they miss the break, remember for a number of years now, we have to pay a premium, a 1 hour at base pay, if an employee, let's say an 8-hour employee, misses one or both breaks in the day. Okay. Minimum wage. We know from prior legislation that the minimum wage in California was going to go up every year until it hits $15 an hour, and then there are actually some steps after that. But effective this month, if you have 26 or more employees, your minimum is now $10.50 an hour. But we have to remember that the minimum wage in California affects other things. It affects the minimum salary that you must pay salaried or exempt people, And just because you pay that person at least $43,680 a year, you still need to be sure you've gone through all the other requirements allowing that person to be exempt from overtime and record-keeping requirements. For those of you who have employees who bring their own tools to their job, their minimum wage is 2 times the state minimum wage, so that's now $21. And it does impact some commissioned inside sales staff if you employ them. For those of you with 25 or fewer employees, you are doing nothing this month for minimum wage. It's still $10 an hour. You are 1 year behind the larger employers in the changes in minimum wage. But this is interesting. How do you count the number of employees you have? If you're a joint employer or if you routinely, continuously use staff from staffing agencies, you have to count those who are under your control. This may be something new for you, and if it's thrown you a curve, you'll want to investigate this, maybe talk with the staffing agencies. They certainly should know about this, and it may change your perspective on, even as a small employer, what your minimum wage is as of this year. You may have seen news all year long of various cities and locales in Northern and Southern California passing their own ordinances regarding minimum wage. So depending on where you are, you'll want to investigate that. Also, hopefully you all post near the various legal posters that have to be up by now, your California wage order. There are 17 wage orders. Hopefully you know which wage order applies to your business. And because the minimum wage changed, if you have 26 or more, you need to post the new California wage order. Also, to keep in step with another requirement, and just good HR practice for a complete personnel file, document any pay changes that this year brings about because of the minimum wage. Have the employee sign, and the employee gets a copy, and you have a copy in the personnel file. So minimum wage changed. Also, we all know that the day after the election, November 8th, recreational marijuana was legal. But it is still your right to have a drug, marijuana, and alcohol-free workplace. What you would have done is added marijuana to your existing policy. Hopefully your policy has been updated, reviewed in the past couple of years, but certainly as of November, I worked with clients to update their policy, redistribute it, and discuss it with staff, and sign an acknowledgement form that the employee got a copy of the new policy. It's perfectly fine, even though marijuana stays in the system a lot longer than other drugs and alcohol. It's still fine to have reasonable suspicion testing. It's still legal to have pre-employment testing, including marijuana, and to not hire someone if they test positive for illegal drugs, alcohol, or marijuana. If you allow new employees to begin work before the test results are in, I believe you should change that practice and consider completing all your new hire, your pre-employment processes before the first day of work. In 2016, we had smoke-free workplace rules where we added vaping and vaporizers and such. We were not to designate smoking break rooms inside our facilities, and we had to take reasonable steps to prevent non-employees from smoking. So that shouldn't be new, but it did come up in legal updates that I received. Harassment, discrimination, and retaliation. In April, all of you, I'm sure, were aware that your policies on this subject needed to be updated. Here again, updating policies, distributing and discussing with employees, and having a signed acknowledgement form in the file was very important. The key for me when that law changed was have a complaint procedure that gives employees as many avenues to bring their concerns forward as possible. There was a lot of important language in what we saw the DFEH change last April. So if you haven't read that before, you might want to do that to make sure your policy is in good shape. And let's keep our eyes open this year for what may continue to evolve in that particular arena. Paid sick leave. Remember 2015, we had a ball. But just a quick little update on California paid sick leave. I've run into some employers who really didn't put into writing a comprehensive policy. And in California, if you haven't done that, then if there are any issues that come up, you will have to abide by how California wants you to manage the paid sick leave that you provide employees. Many employers just had their payroll company start accruals or start accounting on the paycheck stub for the balances and the usage, and that is a good start, but you really need to have a written policy. And now, in 2017, if your business has federal contracts, there are now different requirements. If you have federal contracts, more sick leave is provided, and you'll want to go to the Department of Labor website and investigate this or talk to your employment attorney about what responsibilities you may have in this regard because of the federal contracts. And know that it's more sick leave just for the employees who work on that contract, which adds a bit of disparity among your employees. Those who work on the contract and those who don't may have different sick leave benefits. Again, because there are many local ordinances that took their own approach to minimum wage and accelerated the increases, some local ordinances were regarding more sick leave. So if you are in the cities mentioned here on the slide, you may want to, you will want to be sure that you are on top of the local ordinances. I believe even Pasadena has some changes too, but that is minimum wage, not sick leave. Commission staff, be sure you know the changes in how to calculate the rate at which sick leave is paid. It is not just base wage for hourly staff. I was not going to cover the details on that today, but sometimes we forget commission staff, and so it's important that you are calculating the rate at which sick leave is paid for hourly staff. Exempt staff are paid sick leave like any other time off benefit they have. Possibly you've heard that in March, restroom signage must change. If you're on the webinar today and you're a sign company, that could be a good line of business for you right now. But it will affect the restrooms you may have at your business where there is one toilet or urinal, one sink, and the lock on that restroom is controlled by the user. The signage must be changed to those that you see here, all gender, no gender, gender neutral. Pictures and words of males and females or both are not allowed. And the interesting thing about, I have clients who have a restroom like that and it says restroom. And at a legal seminar, I was told that'd be okay. I receive legal newsletters via email all the time, and recently one law firm said it's not. So depending upon the signage in your business, you'll want to confirm if the word restroom alone is okay. Might be that the person who provides signs has become an expert on that and would be a good resource. Joint employer and use of agency staff. If this applies to you, make sure, we've needed to be sure for many years that the agencies we use are fully compliant with state and federal law. And it's important that you know the employer of the individual from that's the agency, is liable for not following the laws, the employment laws, but you may also be liable the organizations who are using the agency staff. So it's not as simple as calling and getting agency staff and having agency staff working for you for a long period of time. You will want to do an audit of agency staff and ensure that you're comfortable with the level of liability you may have if that person filed some type of employment claim with the state. So more investigation would be important for you to do. Moving on. If any of you are in the businesses listed here under the bullets, there are some additional changes for these types of employers or these industries. So be sure you investigate if that represents you. And if you have wellness programs, the Equal Employment Opportunity Commission does have requirements that now apply to new plans. What you've done in the past is fine, but going forward, you will want to be familiar with the EEOC requirements if you have a bona fide wellness program. One other thing before we go what's ahead, I have a note here. If employment contracts or, oh yes, if you have employment contracts or other legal agreements, employment contracts, confidentiality agreements, proprietary information agreements, arbitration agreements, you will want to review the SB 1241. SB 1241 in California, that's Senate Bill 1241, because no longer can employers require, if there is adjudication, we can't require that that dispute be adjudicated outside of California. And I have seen some documents like that in the past. So if you have legal agreements, employment contracts drafted by attorneys, either call the attorney, who will be on top of this new requirement, or take a look at SB 1241. So what's ahead? There will be, for those of you who have 25 or more employees, there will be a new brochure that's required about July 1st. California may develop it and publish it before then, and that's when it will be effective. I routinely send out short little heads-up kinds of emails about this and to my contact list, and so I'll let you know. But it's a brochure about the leave of absence that's possible when someone has been a victim of crime, domestic abuse, and such. You probably know there are certain leaves of absence that you must give employees in certain situations, and there will be a new brochure. So this will be a brochure like right now. You have to give new hires a workers' comp brochure, the paid family leave brochure, sexual harassment brochure, and paid family leave brochure, state disability insurance. I'm not sure which one I said there. So there'll be at least 4 or 5 that you give new hires. There probably will be change. There will be change in paid family leave benefits, but that's not till next year, so stay tuned on that. And of course, we'd have a revised brochure by then. Just a heads up, there's no impact for several years, but California is developing a retirement savings program for employers without a retirement plan. It's funded by the employees, and it's something that they will have to contribute to. They will have that benefit. It's sort of like they contribute now to the state disability insurance benefits, the PFL benefits, through a payroll deduction. But again, that's years to come. In a couple years, you know we have outdoor heat illness regulations, and those keep getting updated pretty routinely over the past 4 or 5 years. Well, in a couple years, we will learn what California expects us to do when there is indoor heat. If you have an office with air conditioning, you're probably fine. If you are, for instance, an auto body shop and have everybody is in the shade, but they're certainly working in the temperatures that are outside, and so we will stay tuned for what the requirements will be. And if you have 100 or more employees, the EEO-1 deadline for your report that goes to the federal government, by 2018, that deadline will be March 31st. So, sort of as a wrap-up, I sort of put together a to-do list. Some of you probably should do all of these. Some of you have already done some of these, or some might not apply to you. But certainly the I-9 form is alive and well this week. Remember to read the documentation requirements and procedures and give the instructions to employees, to the new hires for completion of their section. The update of the application form regarding the criminal conviction question and what you don't want them to put down. Talk with hiring managers about what they currently discuss in an interview with candidates regarding pay. Maybe they don't discuss anything and that just comes through you. That would be great. But become familiar with the important changes this year in the Fair Pay Act. You might need to update your rest break policies as we discussed. And probably important to the managers are the ones who are scheduling or rescheduling breaks. The managers are the ones telling them, hey, I don't want you to leave during your break. You need to be sure they understand what your policy is on breaks now. Make sure the new minimum wage is managed properly and all the various tentacles that involves. If you haven't updated your harassment policy, distribute it and obtain an acknowledgement, signed acknowledgement, I would do that. Same with the drug-free workplace policy. And make sure you have a written sick leave policy that's correct and complete. Restroom signage is March 1, did I say? And then if you have agency staff, make sure that you're in good shape with that. Dane, do you want to cover questions now?
Yes, thank you, Cindy. We actually just had one question. Does the Fair Pay Act apply to licensed clergy acting in the role of clergy?
That's a good question, and I have a little knowledge on that because I provide pro bono HR services to my church. And this would be a very important question for an employment attorney, and even more specifically for an employment attorney who either specializes or has a background with churches. My non-legal thought is that it may not. And there is something in the federal law called ministerial exemption. And some employment attorneys still in California who I talk with differ in their opinions about questions regarding exempt status and other pay questions in the churches. But when it comes to clergy, the ministerial exemption would apply, and I would investigate that further.
All right, thank you so much for all that valuable information, Cindy. We appreciate it. For our attendees, you can see Cindy's and our information on the screen. Please feel free to contact us with any questions about Cindy's presentation, HR, or benefits administration in general. Please also keep in mind that we offer handbook development and ERISA compliance services at discounted rates or potentially at no charge depending on the size of your company. If there are no more questions,
Jane, there was
actually, I'm sorry, Cindy?
Yeah, there's one.
Yep,
Let me see if I can respond to Ed. There's a single-use restroom inside a co-ed locker room, changing room. I would think outside, the outside could say all-gender locker room, and then it would imply that the restroom is all-gender restroom.
Alicia also asked if the slides will be available for downloading, and we don't have them at a download point per se, but if you contact any one of the people on the screen, Cindy, Nick, or Kendra, they'd be happy to send those to you.
Very good. Thanks, everybody. And 2017 wasn't too cumbersome or problematic, but there are some details to attend to, and I hope I've given you a good start to do that. Thanks.
Thank you again, Cindy, and if there are no more questions, I just want to remind everyone that our next webinar will be in February, and it'll touch on wellness programs as well as the future of dental programs. I'm going to go ahead and end the session now, and thank you all for attending. Have a great day.